Take the deal. Give me the $100. I'll find your cat. Can you? What? I'm hearing mumbling. So this type of offer is a kind of a special situation. You cannot accept this by saying yes. It's called a unilateral offer. And the only way to accept it is to perform. So how do you accept the deal?
Find the time.
So in this case, performance is acceptance and consideration and performance. They're all the same thing. It's one action. It accepts the contract, it performs the contract, and it's the consideration for the contract. When that is a requirement, it's called a unilateral offer, and it results in something that's called a unilateral contract when you accept. But if you do take the cat there, they can't go, I was just kidding, because it is a contract. And you've performed it by accepting it, and you got to pay. These aren't hard concepts, right? Common? Is this hard? What do you mean? It's just hard because your brain's mush. Okay? Because of all this other crap. Trust me, you didn't want to go any further than that. Okay? All right. Go ahead.
So this invitation to treat, the quantum merit, and the unilateral contract, are those all parts of consideration, or are they all separate?
Yes. This goes back to this problem. They are, but where do they fit? Unilateral fits here, and it fits here, and it fits there. And again, it goes back to, when you have facts, you have to know this rule, that you are accepting it by performing. Because when you're asking is what was offered the same as what was accepted, and when you brought the cat, you have to know that when you brought the cat back, you accepted the deal, because that's how unilateral offers work. That acceptance is the consideration and its performance. And then you say, was there consideration? Yeah, there was, right? They promised to pay you $100 and you returned the cat. You both gave something, right? So part of the problem with the courses is when we do like negligence first, we deal with these concepts in a very straightforward, linear way, right? And you're looking for it and you're finding it and you're going there. The problem with contracts is you can't do it like that. You can't just go sequential, step by step. Here's the things. We write this out, we got the answer. You got to use the rules when they're triggered by facts and need to be used. There are some rules you're always going to have to use. You need to have this. 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 But you have to understand that sometimes to get this, you need to know that. Right? And sometimes to get this, you need to know this. Right? So, if I was to ask you, will you buy the chalk for $1? Do we use this rule, whether it's an invitation to treat? No. Offer's clear, obligations are clear. Do we use quantum merit? No. Right? We don't even bring it in because it doesn't come in. Do we use unilateral? No. So, for you to be even going there, the facts have to have taken you there. And I've said this before, you're starting to probably be in a position to understand what I've said. The problem with contracts is people try to drive down the road following the directions. You have to know that that little set of facts that I talked about right here has triggered a turn. You've got to go here because of that. And if you don't know that that will make you have to go here, you will arrive at a spot and think you're at the right spot. But because you didn't use a rule that was triggered by the facts, the spot's wrong. And the other way that I've described this is, you have to know everything, always. You can't start looking for one thing at a time, because you may need this in the process of dealing with that in order to get over here. And you'll see this better when we start doing the case studies. I will tell you that the case studies are harder than the exam. They're hard for two reasons. One is that it's a new thing, right? You've never done it before, so it's going to be hard because of that. It's just because it's new. And they're also have really nasty complexities to them. But those nasty complexities start to get you to understand how you have to think, and that actually should make the exam a tiny bit easier. It's still challenging. Do you understand what I'm saying? So, this is why I tell students, and if I can give you any advice that you should just please follow it. Okay, if you want to do okay on the exam, you have to learn what I've talked about tonight over the next week as well as you're ever going to. In other words, you have to learn it like there's going to be an exam on this next week. Students don't. What they do is they go, oh, well, I'd rather watch Netflix or do this and stuff like that. Right? I mean, who wants, right? Life is joyous, right? And what happens is, they get to next week and they go, oh my God, class tonight, right? Wasn't I supposed to do homework, right? And then they go, and this happens over and over and over again until you get to the point where you're going, oh my God, I got an exam next week. I best better learn this. And it's too much. It's too hard, right? And it becomes overwhelming. If you learn it as well as you possibly can every week, which means go through it, think about it, write it out again, think of examples for yourself, and you do that probably for at least 6 hours a week, maybe 8. Next week comes, you got it, or if you don't, you know to ask questions, and then we can fix that, and then you're going to go on. So, students who don't do well often just don't have the willpower to prepare, right? And students who do often do. That's generally the case. If you have the willpower to do what you need to do over the next week, you'll probably do much better. Then it's just a question of learning how to write the exam. Okay? So, I keep repeating this over and over again. It'll become more apparent when we start doing case studies. We're getting close, but we're not there yet. Let me deal with this. Let's finish this off. This isn't a hard concept. It's an easy one. What?
What do you like over there? Legal?
Legality.
Oh.
Sometimes called, is it legal?
Sorry.
Okay. So, please don't mistake when I tell you what this is about for the test. They're different. Understanding what this is about helps you understand the test. There are circumstances in which courts will not allow them to be used. They won't let you go to court. They won't let you use a judge to sort this out. And it basically has the impact of blocking your ability to go to court. And it's because courts don't want to be used for things that they don't think are right. So, we'll start with the example. If I said, I'll give you $5 if you punch her in the nose, but you got to make it bleed. Right? And you say, okay, we got a contract, right? So if we ask the questions, is there intention to create a legal relationship?
Yes.
Yeah. Or arm's length, and there's $5 involved. Okay. Is there consensus?
Yes.
I made an offer. You accepted that offer. All right. Is there consideration? What's she giving? The punching, the effort, time and effort to punch her in the nose, and I'm giving $5. Okay. So, okay, if you don't do it, I'm suing you, right? We go to court. What's a court going to do? Go, ooh, icky, right? We're not going to enforce that. So this is the concept that is called legality. And it's got, the twist to this one is there are two tests. The first test is, does either side have to break the law? Either side have to break the law. Right? Who's a fast driver? Anybody? Fast? She's admitting to the back. What's your name, sorry, back there? Is it Caitlin?
Taylor.
Taylor?
Yeah.
Okay, Taylor's a fast driver. I knew it was going to be a woman. They tend to be so fast these days, okay? So I say, Taylor, I need this chalk driven to Winnipeg. And it's got to be there by 10 o'clock. Will you drive it to Winnipeg and get there by 10 o'clock in your car? And she says yes. So if we go through the elements, Denchkirk Blue is, yeah, consensus, drive the chalk to Winnipeg. Okay, consideration, she's giving the time and effort to get to Winnipeg. I'm giving the promise to pay, how much did I say? Did I tell you? $300, okay, to get to Winnipeg. I'm giving the promise of $300. Does she have to break the law?
Yes?
Yes.
How come?
Speed.
Is she going to have to?
No.
Could she drive it to Winnipeg in an hour and a half without speeding?
No.
So then does she have to break the law?
Yes.
That contract will not be enforced by the courts. It would be what's considered to lack legality, and therefore that element's missing. Court won't enforce it. Just change this, Taylor, because I know you're a quick driver. If I say, Taylor, I got to get this chalk to Winnipeg as fast as I can. I'll give you $200 to get there as fast as you can. And she gets it there by 10 o'clock. Is that a valid contract?
Yes.
Yeah.
Why? What's the test?
As fast as she
What's the test for legality?
does either have to break the law.
Have to. Did she have to?
No.
No. That's a fine contract. The fact that she broke the law is irrelevant. The question is, does the contract make her have to break the law? So she doesn't have to, she chose to, but that's not the question. The question is, does she have to break the law? She doesn't with that second deal, get there as fast as you can. Therefore, that contract's valid. There's no problem with this. Got this? So, the first test is, do they have to break the law? But there are circumstances in which a court will not be used for things that they just think are bad for society. Now I'm going to give you an example of this so you understand what this is, but this won't be the test either, because, and I'll explain why it is in a minute, okay? There are things that a court is going to go, ew, we don't want that type of thing enforced in our court. It's not good. Even though it's not illegal, it's bad. So who has a child? Put up your hand. Oh, I know you do, okay. So, Jenna, right? So if I said, Jenna, I'll tell you what, I'll give you $100 if you only feed your kid macaroni and cheese for the next 2 months. Okay? Now, if we look at this, is there intention to create a legal relationship? She says, are we at arm's length? Commercial?
Yeah.
Yeah. Consensus. What was offered? Feed the kid macaroni and cheese for 2 months. Right? Is what was offered the same as what was accepted? Right? Was it? Yeah. Consideration. What am I giving? $200. What's she giving? Whatever it is to give her kid, the promise to give her kid macaroni and cheese only for 2 months. Is that illegal?
No.
No. Is it bad though?
Yeah.
Yeah, it's bad, right? And the court would go, ooh, we're not going to subject children to this type of situation. even though it's not illegal, and when I sue her when she breaks it, the court's going to kick me out. Not because of the first law, but because of actually the second one. So the second one is what's referred to as public policy. And the problem with public policy, illegality, is it's huge. There are so many things that you cannot go to court for simply because the court's going to go, no, we don't like that type of thing. It's not the way we want society to be. We're not going to enforce it. It involves anything with respect to children. It involves lots of different things in terms of just, we don't like it, right? It's just not the way we're not enforcing that agreement. We don't like it, okay? So because it's so big, I can't really expect you to understand how huge it is and all of the different examples. So we're going to, in this course, focus on just one. And the test is going to be focused on that one. Does it limit someone's ability to earn a living?
Can you repeat?
Does it limit one side's ability to earn a living? So when you're dealing with legality, you have to deal with both of these. The first test is, does either side have to break the law? The second one is, does it limit anyone's ability to earn a living? Okay? Do contracts ever restrict your ability to earn a living? How many of you have a job? Let's ask this a bit broader. How many of you have had a job in the last year? Put up your hand if you've had a job in the last year. Okay? So, how many of you had an employment contract? All of you did. Otherwise, why did they pay you? Right? Employment is a contract. What's the offer? You apply for the job and they say, okay, you want to come work for us?
If you do these tests, we'll give you money.
Yeah. And you say, okay, I'll take that. By the way, can you quit a contract? Can you simply say, you know what? I don't want to do this anymore. So if I turned to you and said, I'm going to tell you a secret, and I'll pay you $5 to never tell anybody. How long are you under that deal for? Okay, can you simply say, you know what, it's been a few years, I think I'm going to quit. I'm just going to tell people the secret. Can you do that? So how long does an employment contract last? Can you quit a contract?
You can terminate a contract.
I said, you said you would hire me and pay me to work for you. Can you say, you know what, I don't think I want to do that anymore. Can you quit a contract, folks?
Sure.
What? Can you?
Well, what's resignation?
Breach.
You can quit, you can do a breach.
That's a breach. You said you would work for us. How long for, folks?
It wasn't stated.
What?
It wasn't stated.
Therefore, how long is it?
Indefinite.
Yeah. And when you quit, you breach. When they fire you, they breach unless
They have grounds.
they have grounds. But they can't say, oh, just don't have any work for you anymore. No, we're going to quit this contract. That's breach. That type of breach has a name, and it's normally considered to be a tort, but really it's a breach of employment contract. The tort is called wrongful dismissal. But it's actually a breach of contract. You promised to pay me to work here. You're not paying me anymore. That's breach. So sometimes people call it the tort of wrongful dismissal, but it's really a breach of contract. You breach too when you quit. Yeah.
Can it be considered as either? Like in the real court of law?
In the real court of law, it doesn't matter what it is. The question is there loss? Is it proved? If you go one way, you're getting the same spot as if you go the other way. It doesn't really matter. So, what are you out if you quit? Sorry, what are you out if you're fired?
Their wages.
For how long?
From that employer.
Keep going. How long?
Indefinitely. Indefinite.
No. How long are you out the wages for, folks? I'm hearing a mumble. Who said that? Very good. When you get a new job, are you still out?
No.
So the way that this type of breach works is your loss is actually the loss of wages until you get another job. If you get a new job, are you actually out anything? No. So this is why with what's called wrongful dismissal, they will normally calculate, a court will normally calculate on a basis of a formula that is based on estimating how long that will be. And the general rule is you're entitled to a month for every year of service. So if you work 20 years, you should get 20 months. If you haven't gotten a job in 20 months, it's not because they fired you. It's because you should have been. That's the general rough rule for wrongful dismissal. But I need to go back over here, okay? There are contracts that limit your ability to earn a living. They fall under two different types. An employment contract. Has anybody had an employment contract where it said, if you take this deal, you cannot work outside of this situation? Yeah? Can you tell me what it is? You don't have to. Might be. Grocery stores are commonly like that, right? Anybody work for a grocery store? Did you?
Yeah, I did in high school.
Which one?
The co-op.
Did it have a clause in there saying if you work for the co-op, you can't work for Sobeys or
I
Loblaws?
don't think so, no.
It may not have. So the co-ops may not have that, but I can guarantee you, if you work for Sobeys, there's a clause in there that says you cannot work for Loblaws. And if you work for Loblaws, there's a clause in there that says you can't work for Sobeys. So, what happens here? There are two types of restrictions on here. So, in employment contracts, there are two different circumstances that exist. They will commonly have a clause that says, while you work for us, you cannot work for someone else. The other one is, after you work for us, you cannot work for these people. They both restrict your ability to earn a living because they're a contractual obligation. Getting a little hint here, folks. One of these, the court is more likely to say it's okay. Which one?
During
Why?
conflict of interest, whatever.
Why are they going to say it's okay to restrict you while you're working? It's not really the reason. It's not because it's got so much damage. Why? What can you tell about this circumstance? Why is it not that bad to be restricted during?
Because you're employed and you're gaining a living.
Yes. This is not a complete, you've got a job, right? So the starting point for clauses that are during, if it says in your contract, while you work for us, the starting point is they're valid. In other words, they are not going to be removed by the court. They're going to be accepted as being a valid restriction. It's not going to be limiting your ability to earn a living because you got one, okay? But they are valid unless they are unreasonable or unnecessary. So if I can go back to the woman, what's your name, sorry?
Jessica?
Jessica? With a J?
Yep.
Okay, I can do it. All right, so Jessica, let's presume that it said, while you're working there, you can't work for someone else. Would you consider that to be an unreasonable or unnecessary clause? So let's say she's working 12 hours a week. And it says, you can't work at Loblaws. Is that unreasonable and unnecessary? Here's the question. Are people going to go, oh my God, Jessica, she's over at Sobeys We got to go over there to shop. Think that's going to happen? Nothing personal, but do you think it's going to happen, folks? No. Is it unreasonable and necessary to restrict her?
Yes.
Probably. But if she's the manager or has information, then it's probably a valid clause and the court will uphold it. What about after? After, the starting point is it's invalid. In other words, the court's going to remove that clause from the contract. You're not going to be breaching it when you get another job. Unless the employer can show serious injury will result. Now this can happen, especially if you have a higher up position, you have specific knowledge, you know customers, you've got a lot of clients. So the starting point is that clause is invalid and will be removed unless the employer can show this is a situation where removing that will cause a serious injury. Not a little injury, not some injury, serious. So the example I always give here, folks, is Coke and Pepsi. And it's something I talk about if you take Law 2, when we talk about intellectual property. So Coke is a formula. There's a formula for making Coca-Cola. It involves a bunch of things. It used to involve what? Cocaine, right? That was the good stuff, right? Get you addicted so that you went and bought it, right? Good, clever marketing in the old days, all right? But that was part of the formula, okay? So there's a formula for Coca-Cola. That's why it's called Coca-Cola, right? It's because it had cocaine in it, all right? Pepsi-Cola had Pepsi in it. I don't know, all right? But Pepsi-Cola also is made with a formula, and they're not the same formula. So Pepsi-Cola, the company, wished to protect its formula. And what it did was the normal thing, which was they patented it. So patent is, you go down to the patent office, you show that this is a unique formula, and you patent it. Patent gives you the right to exclusive right to produce and market for 20 years. How long's Pepsi been around for? More than that. Their formula, their patent ran out. And when it runs out, you can't repatent. You can't repatent. You get that 20 years and that's all you get. And as a result of that, any company can make Pepsi. Okay, that's the deal. You get 20 years, no one else can make it, but after that anyone can make it. That's what happens when you patent it. So if you go down and buy RC Cola or President's Choice Cola and everything else, they're all Pepsi. Because they can copy that and they're not infringing patent. Okay. Coca-Cola said, we don't want that. So what happens with Coca-Cola is they did not patent it, because patenting requires you to disclose publicly that this is the formula that no one else can use. And they didn't want to do that. So how they protect their formula is they lock it in a vault. And they just don't tell anybody what it is. And this is kind of a very dangerous thing, because if you were to sit at home with your chemistry set trying a bunch of concoctions that can kill you, and you stumbled upon, this is Coca-Cola. Could you patent it?
Yes.
And what would happen? Coca-Cola could not produce it or market it for 20 years. That, by the way, is what I would consider to be an extremely effective employment option. Find the formula for Coca-Cola, you will never have to work again, because they will pay you for it. Right? So, yeah, folks, billions, right? All right. So, if we talk about this, do you think that there's a clause in the people who work for Coca-Cola who know the formula, there's about 8 of them, that after you can't go work for Pepsi? Yeah, there is. Okay, definitely. And would you agree that serious injury will result?
Yes.
Or could result? Yes. So they would not be able to, and even though the starting point is usually that these are removed, that's a situation in which it wouldn't be. And by the way, just for interest's sake, folks, Coca-Cola, there was a guy that actually had seen the formula about 7 or 8 years ago. And he phoned up Pepsi and he offered to sell it to them for, I think, around $400,000. Well, Did Pepsi buy it? Is that cheap, by the way?
Yeah.
Really cheap, right? Did they buy it?
No,
Why not?
because they have the formula.
Do they have the formula for Coca-Cola? Could they put Coca-Cola out if they had the formula? They just go down in? And then what would happen? No more Coca-Cola. Okay? And they didn't. They didn't buy it. They phoned the police. The guy got arrested. He went to jail. That's theft of intellectual property. And the reason they didn't buy it is, of course, because Pepsi is better. You know that, right? Right? Yes, Pepsi is better, folks. They proved it. They proved it in the 80s with the Cola Wars. You people are too young mostly to know about this, but in the 80s they had the Cola Wars. And this was, Pepsi Cola went and they did blind taste tests. They were everywhere. If this were in that time, there'd be 2 people downstairs sitting in front of a booth with blind taste tests. There'd be a couple at the mall. It was everywhere. My brother actually was part of that campaign. He got to operate the Pepsi robot. You know what it was called? Are You Dry To? It was called Are You Dry To? It was the Pepsi. And he used to chase old ladies in the mall with this robot. That was what he did for fun. Anyways, and they didn't. They phoned the police. The guy got charged. He went to jail. Trying to steal intellectual property. Okay, so with employment, you got to say, okay, is it a during or an after? If it's a during, it's probably good unless you form the opinion that serious injury, or sorry, it's unreasonable and unnecessary. Okay? If it's unreasonable and necessary, it gets removed. After, it will get removed unless the employer can show serious injury result. That's how this works with respect to employment restricting ability to earn a living. There's one more thing we're going to do tonight, and then we're going to call it quits. There's one more type of employment situation, and it's selling a business. If you have a contract that sells a business, there's often what's called a restrictive covenant. You don't need to know that. But it basically says, I'm buying your business, you can't compete with me. Right? I mean, if I'm buying a pizza place from the guy that had the pizza place before, I don't want him opening a pizza place next door. He's kind of good at what he did, right? He got the business going and everything else. So when I buy the pizza place, there'll be a clause in here that's called a restrictive covenant. Does it restrict your ability to earn a living when you can't open a pizza place? Is it a restriction?
Yeah.
So that when I buy a business from you and I restrict your ability to earn a living, we get down to here again. So the basic rule is this. When you have a restriction, it has to be reasonable with respect to both time and distance. If it is, the court will leave it alone. But if it's unreasonable for either time or distance, what happens is the whole thing gets removed. It doesn't get fixed, it gets removed. So, let me talk to you about what this means. Time is an easier concept to understand. Generally speaking, a restriction of 6 months is fine. Probably the extreme end of what's fine is 2 years. If it's longer than 2 years, it's probably unreasonable. Why? Because if you can't get your business that I sell to you done within 2 years, if you can't get it established in 2 years, it's not my fault. And I shouldn't have to sit on my ass not being able to make pizzas because I sold the business to you when things. So it's 2 years is probably the outer limit. And I see 5 or 10. Those are too long. And what happens if it's too long? And therefore, what does the court do with that clause? They remove it completely. So there is no restriction. So this would be a thing, folks, where you go, oh, I'm going to buy your pizza place. And they say, okay, I want something in here that says you can't work for 6 months. And I go, why don't you make it 10 years? Oh, you would agree with that? Sure I would. That, by the way, would be playing fast and loose with a judge, and they may just bite you in the ass because they think you're being a smart ass. You agree to that? Yeah, okay. So it's got to be distance depends on the product. And really it's the length, the distance that people will go to buy that thing. And this depends on how many of you buy gas for your car? How far out of your way would you go because you like the gas station? Would you drive to Minnedosa? Oh, I really like the gas station there, right? They give me 3 cents a liter. Would you drive? How many of you would not drive to Minnedosa because you, out of your way, like drive from Brad? Yeah, it's too far, right? So if the distance is beyond that point, if you're buying a gas station, maybe 10K, 10 kilometers, right? But what if it was professional skates? You know, you are the skate maker that all of the NHL players wear. Is it 10K, the distance in which people will go, or is it way bigger? It's probably across Canada or maybe North America. So what is reasonable with respect to time is always probably between 6 and 12 and 24 months. Distance, you can't say a distance, it depends. How far is that market really going to be? If it's beyond that, if it's the world, it's going to be struck down. We've covered a lot, eh? Here's the good news. It's all downhill after this. This was the hardest class. Go ahead.
I understand it. I just want to throw an example if there was a business.
Yeah.
So, Fire Pizzeria on Vic.
Okay.
The guy that owned it sold it.
Yeah.
I don't know how long it was before another one opened, but there's another brick oven place that opened up down at the Corral Center.
Okay.
So, would that be, let's say it was 6 months, but it's the same work.
So it depends on the contract.
Maybe never in there, not an issue, obviously.
Yeah. So what would be reasonable? Would for what I call a little bit of a specialty pizza, would you go as far as the Corral Center to get it? Would you? Yeah. So I think that distance is reasonable, and if he breaks it, it's breaking the clause. And therefore, it would be breach. See this, when it comes to sales to business things, we're talking about is the clause in or out?
Now, caveat to that, Fired was homegrown in terms of and not a it wasn't a franchise. Does it matter if it's a franchise?
No, it's what the agreement says.
Okay.
So you can have a contract. I buy your business. I want the right to get your customers too. And then sometimes it's okay and sometimes it's not. And I'll restrict you to make it so I can get your customers too. Sometimes it's okay, sometimes it's not. We have to apply these tests to it. Okay? All right, folks, you can go.